I am on time. I'm very happy about that. You guys know I don't like tardy people. In any event, I hope you guys had a fantastic day. I had another busy day, but I did get to watch the majority of yesterday's hearing. This was actually a really good hearing. This was a fantastic hearing. So we're just gonna touch on some points. What's up, Brooklyn? We're gonna touch on some points. And while I was listening again, so I started listening to the hearing, must have been around noon. I listened to Alan Jackson. He made some pretty good points. I took down the timestamps, so that's what we're gonna go over. And then, what's up, Jason? And then we're gonna get into the prosecution. The prosecution, I've watched about 50% of their response or the opposition. But while I was listening to, I mean, I had previously said this. What's up, Benji? I previously said this. The prosecution has a big problem with Proctor. Okay, Proctor is a problem that is not going to go away. So I think it makes sense for us to listen to Proctor's cross examination. I mean, I'd probably want to listen to the direct again so we have full context. I just do not know how the prosecution gets over the Proctor problem because everything that Proctor has touched is pretty much tainted. Okay. Um, Yesterday's hearing, Alan Jackson was focusing, not even focusing, he was alleging that Proctor, I mean, he did not use the words directly, but that is exactly what he wants the court to infer. Okay. That Proctor may have tampered with Karen Reed's vehicle, okay, in the Sally Port. That was pretty much the crux of his motion to dismiss. And in all honesty, Proctor is tainted. He caused this upon himself. He created problems he should not have created, and I just don't know how the prosecution overcomes that. Overcomes. Sorry, I'm parenting. I'm sorry, folks. I am parenting. I should have pulled up the radio, not the radio. I'm now talking about a radio. Zeta's talking about the TV. So let me just share my screen. For the prosecution, they have a big problem on their hands. Okay, we'll eventually get. I think this is where we left off. But I have screenshots. Hold on, I always have screenshots. I thought Jackson did a pretty good job with his motion to dismiss. There are just a few points that I want us to listen to together. So we're going to go to 220. Is this Jackson? That is Jackson. Is this the same channel? I think this is Long Crime. That's Long Crime. All right, one moment. I could have pulled this stuff up, but I worked a little longer tonight and I just stopped working. I stopped working like what? I stopped working at 8 p.m. So I have a hearing. I have a hearing next week, so I have to be prepared. All right, let me just find the timestamp. It was 2/20/17. Maybe let's start at 2/19. Even 2/18 is good. God damn it.
But the best way is to
Hold on.
show you the defense before sit note on
That's too far.
regulatory footage. It was his trial when asked about all this footage because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. None of it.
Okay. So Jason, shout out to Jason. Jason's always coming through with facts, okay? That's a one thing about Jason and Brooklyn. They have something, but I mean everybody brings something, okay? Everybody contributes. Jerome, he's my co-counsel. Benji's my co-counsel as well. Okay, let's get into this. Jason says Bev is letting the state's so-called dog expert on dog bites testify without an evidentiary hearing. And what was her reasoning for that? Because again, we have to go by reasoning. I don't know. Jerome's looking at something. I don't know what I don't know what Jerome's looking at. But let's get into Alan. Though I could have written this stuff down, but I was working when I was watching this.
We couldn't have evidence that had been secured from Canton Police Department. That video.
Sorry, that's you in just a moment, Your Honor.
Oh, I'm tired, you guys. I'm really tired.
June 10th. It was either June 10th or June 12th, but let me double check.
Well, she's looking for that, Your Honor. May I
Please
proceed?
go ahead. Yep.
Okay. The only thing it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing, and the flatbed and the flatbed driveway footage
Okay.
outside the Sally Port that doesn't show much of anything. It's now been proven that testimony.
I've always wondered, this maybe you guys know I'm always going off on random things, but I've always wondered whether Reed's family and the O'Keefes have, not just that they have met before, but I wonder if they had a relationship, okay? Because these folks dated for, I don't remember how long John O'Keefe and Karen Reed dated for, but I always wondered if they had a relationship, just because obviously the circumstances that they are, I wouldn't say meeting because they're not meeting. Yeah, but the circumstances of this case, obviously this has driven a rift or a wedge between the two families.
That video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it and he received it, according to Sergeant DGM Petro. And it wasn't turned over either. None of it.
We're getting there. The timestamp that I want is really 2:20. We're a little farther out, but you know, it gives everybody context.
Well, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible, with all this sort of years-long flurry that we've just talked about surrounding these Sallyport videos, that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do.
Proctor is very problematic for the prosecution.
Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter.
Right.
In the eyes of the law, Proctor is the prosecution, right, and the prosecution.
And this is why. This is the part that I actually wanted Jackson to get to. Okay, literally, presto. This was a fantastic. This was a fantastic point that he made.
But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, right, and the prosecution is Michael Proctor.
Yeah, I love that. Okay, so we're gonna end right there. I mean, I have other screenshots that I want us to get to, but here's the thing. I believe I mentioned this. Did I mention this last night or not? Let me think. In any event, okay. Under these circumstances, okay, when it comes to evidence that a defendant is claiming to be exculpatory, all right, I've said it over and over again. The prosecution, I don't know if there are any aspiring prosecutors in here, maybe Benji, I don't know. But from a prosecution standpoint, and that goes for defense as well, you have to turn every single thing over. Okay. It is not an excuse for the prosecution to claim that, oh, it was not in our possession, because under these circumstances, um, the police department, law enforcement as a whole, is considered to be part of the prosecution's office. So for the prosecution to argue that no, this is or was on Michael Proctor and not the actual Commonwealth, it does not matter. Okay, it really does not matter. So I like that Jackson made that point, because I thought that was brilliant. I'll let him talk for a little bit, and then we'll move on to the second. Shoot, oh, it's here. Then we'll move on to the second point. But I thought that was a point well made.
And then we move to January
And
20.
I guess this applies to the defense as well, because I think it was today's what, Thursday? On Tuesday, or was it Monday? One of the 2 days, I don't remember. Either on Tuesday or Monday, or definitely not Wednesday. It's probably Tuesday. On Tuesday, when we're listening to day one of the hearings, where Alessi was pretty much trying to distinguish between his knowledge and the knowledge of the other defense attorneys. And when I was talking about blame shifting, that does not work. That does not work, because they are also considered to be one entity. Whatever is known by these other attorneys is imputed to Alessi as well.
8th, 2025, this year.
What's
Still
up,
getting additional
Fever?
videos at that time. This new
Shout out to Fever. I missed you.
camera angle, which is blurry and grainy and wobbly. It does, however, show the passenger side rear tail light as it's towed into the, or driven into the
Okay.
Sallyport garage. The footage is
Yeah, shout out to Benji. Shout out to everybody. Okay. Hopefully, old bag shows
so
up.
grainy and so blurry, however, it's so corrupted that once again, the true condition of that tail light is completely obscure. At a certain point, it begins to defy logic.
Oh, Fever. No, this is not. This is not Sarah Boone. I'm presuming you're talking about Sarah Boone. This is Karen Reed. She is out of, or the case is out of Massachusetts. She's accused of deleting the boyfriend. The prosecution is alleging that she backed, there was some type of fight blowout, something. The prosecution is alleging that she backed into her boyfriend, who was a police officer, and after backing into him, left him in the snow for him to die. That's what they are alleging. The defense, obviously, they're arguing something else. Their theory has pretty much been that the decedent died from dog bites. These I was gonna go off and talk about something else. Let me keep it moving. So no, this is Karen Reed. It is not Sarah Boone. But talking about suitcases, around the time when random fact, but around the time when Sarah Boone was first arrested, there were at least 3 other bodies that were found in suitcases. I was gonna keep track of them, but I got busy. I got busy. That was like 2 or 3 years ago.
And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts
All right. So Jason, do you disagree with the judge's finding?
out.
Because from my point of view, what's her name? I know Oldbag likes that expert witness. Dr. What is Sarah Boone's dog bite expert? I forgot her name. You guys know I don't do good with names. But even for her, I don't know that she's, I guess under Daubert she is qualified, but that's not somebody I would rely on for an expert.
Blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the Sallyport.
All right, so Fever, this case gets interesting in the sense that she's being retried. We actually do have Karen Reed, and then we have the kid out of I think that's Broward County, or do I have the county incorrect? I don't know, somewhere in Florida. In any event, so Karen Reed is being retried. The first trial, the jury was hung. Now they, They're trying her again. I have a question for you, Fever. Did you actually watch the verdict in the Colin Griffith case or not?
The question then becomes,
Not so much if you watch, but do you know what the verdict was?
what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years?
There we go, Dr. Russell. Thank you.
And again, I've lost count how many times the Commonwealth.
Okay, so no, this is not a recent case. I believe it's going on 2 or 3 years now. Yeah, it's not a recent case. He must have died. I think this was around the tail end of COVID, though. Yeah, the tail end of COVID. So, but she is being retried. Trial is set for April 1st. Whether it's gonna go or not, I'm not sure. Maybe it does because they have Beverly Canoni, and she's a no nonsense judge. So maybe they do go.
Makes the claim, quote, prosecutors have never seen this video, end quote. The entirety of the Commonwealth defense on this issue is the indefensible, which is, it just wasn't me.
Yeah, Jerome, I'll eventually have to, make a short video just summing it up for everybody. But I think it might also be helpful for us to rewatch part of the first trial, and we're gonna get into that today because we're gonna start with Proctor. And again, I have to take my notes. I have to take my notes because when I first watched the trial, I was not really taking notes, but I do remember a lot of the testimony. But for context, we do have to watch Michael Proctor's, probably the direct, but we'll start with a cross. And the reason why we have to do that is because I want to pretty much pinpoint all the areas where he's problematic. Okay.
It may not have been you, but it was the Commonwealth, in quotation marks, capital.
All right. Let me find the next timestamp.
The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, after directing, and thus the only remedy is dismissal.
Let's go. Yeah, this was a good point.
This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word.
Okay, Fever has been working. Well, towards the end of this live, we're quickly going to show the verdict, okay? Just for your sake, we'll show the verdict.
Resolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police.
All right, so Jason disagrees with Beverly Canoni. I'm going to have to read the decision for myself.
The Canton Police Department over and over and over again, and now we know through this new revelation that it was intentional. The prejudice, the defense.
Oh, you moved where? You don't have to tell me, but where in the South did you live? Okay, that man moved back to the city. Why'd you move back though? Is it cost of living? I mean, the South is cheaper, but they don't pay. They do not pay down there. They definitely do not pay down there. And I mean, I've considered moving back. To Mississippi, but I don't know if it's last night or the night before. I was looking at homes, right? And I'm like, I don't know. These homes are a little pricier than what I remember them being. But yeah, they don't pay down there.
This has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards. Where there's misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct.
Right.
And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298. It's a 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice, and find that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong, because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them.
So what I liked about this second point from Jackson, he is pretty much, again, his argument, he's primarily focused on Karen Reed's constitutional rights. And his argument is pretty much making an example out of Proctor, okay, out of Trooper Proctor. Again, he's asking for dismissal so that the Commonwealth and law enforcement get the message that at least Trooper Proctor's conduct, right, is improper, and that's conduct that should not be encouraged. So if the prosecution is well aware that, you know, cases can be dismissed for them pretty much facilitating in a way or overlooking conduct that's egregious as Trooper Proctor's, then it makes sense for the court to, you know, dismiss the charges. Okay, so let me get to the
Then say, I didn't realize their import. They were designed
230.
specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense trial. It was.
Hold on.
And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession. And it was also entirely withheld from the defense throughout this litigation and throughout the first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence?
I thought this was brilliant as well. I thought this was a brilliant point because, again, he's arguing that the defense was at a disadvantage because not law enforcement, but the prosecution did not turn over the videos when they should have, when they were under an obligation. So I like the fact that Jackson is arguing that it is pretty much possible that the verdict would have, not that they would have had a different verdict, but that the jury would have reached a verdict in Karen Reed's favor.
Which they were entitled, to which we were entitled. But they didn't. Every one of these videos.
I need to keep up with the chat. So the jury was hung. Okay. The jury was hung. Some folks thought that she did it or may have done it, and they were not prepared to, you know, acquit or vote not guilty. Yeah, no, I know. I used to live down there. They don't pay people nothing.
Way compromised.
But it was cheap though, because back in the day, I could send my kid to what is this? Summer camp. I mean, she was like itty bitty. She was actually really tiny. But I could send her to like camp, and it was like, if I remember correctly, I mean, this was maybe 7 or 8 years ago. I don't remember, but it was like $200 and some change. Okay. And then I moved, I moved to the East Coast, and they charge money. They charge real money, like real money. So I'm not going to say how much, but they do charge. They charge a lot for a day. I mean, I'm not complaining, okay, because they watch my kid while I go to work and I make a living, but they charge money. I even considered like opening a daycare, but I'm like, nah, I don't want the law. nah, I don't want little waterheads running around. Nah, I cannot do it. I cannot do it. I cannot do a whole lot of bunch of kids. And then insurance, if somebody's kid chokes or something, then here comes law enforcement. So no, 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 no.
The videos that we did have. And the compromise always conveniently obscured the truth and obscured Miss Reed's rights.
That's good. That was really
This is
good.
an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though, and it's the cumulative effect of all.
Brooklyn, who are you saying this to, Fever or me? Because if it's me, how do you know? I don't live in in either of those
These
states.
gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. For the Commonwealth to have all this footage for a solid 3 years.
Yeah, I'll have a recap video. I just have to, again, I'm going to have to watch a lot of this trial because I don't like to rely on these reports because they are hardly ever focused on the things that I'm focused on. So
Years and hold it back from us the entire time, it makes one question what was going on with that evidence. And I have to say, in terms of lesser remedies, Your Honor, what's interesting is that
Jerome,
the exclusion, obviously the exclusionary rule exists.
I understand that does not help the defense.
It doesn't help the defense. And I appreciate the
all
court
right, Jason.
finishing my thought on that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands.
That's funny, Fever.
As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case.
I mean, Jason, I've seen worse things. That is, I explained that to Old Bag last night. Like for folks in larger, let me put it this way: for people that do not practice in criminal courts all the time, there are a few things. Every once in a while, something happens where I'm like, I don't know about that. Like Fulton County was a lot of that. I don't know. They were a little off out there, but to me, this is a proper no. But it is something that for an attorney that practices in a smaller county, okay, it is something that you're going to see over and over again because in really small counties, these little towns and villages where people grew up together. They were probably in kindergarten or something together. Their kids go to school together. They play ice hockey and all sorts of things together. Not only do they tend not to investigate, or here's the thing, I don't think they're properly trained. Okay. I don't think that they're properly trained, which means that they don't properly investigate. But we also have to consider the last time when this county had a murder, or if they actually ever investigated. Okay. Because again, in smaller towns, smaller counties, they don't receive the same type of training that you will see somebody that's in a larger city, like in one of the boroughs or a Boston, larger cities like Washington, D.C. So it's just, again, not to say that they're disadvantaged. Again, maybe I'm just jaded. I've seen a lot of improper investigations where if I'm comparing on a scale, I'm like, but yeah, I mean, I don't know, they weren't properly trained. But we need to look that up. The last time that they had these type of charges out of the county that Karen Reed is charged in. Because I've bounced around from job to job, but I once worked in a jurisdiction as a public defender, and when I was there, I just know that I represented somebody on a first appearance for a murder, okay? And it was a big thing. It was a huge thing. They had They had the media and everybody. It was really big. It was on the news. And the reason why it was a big deal is because there had not been a murder in that county for over 40 years. So I know different circumstances, but I've always wanted to see what happened to that kid. In any event, let me move on because I have until 10. I'm out here over talking. You guys know I have a new regimen. I worked out today and I feel so good. I'm tired, but I feel good. And I need to work out in the morning as well, so I need to go to bed on time.
At this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here. This will give the court a much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So
Yes, that is correct. I'm so late with these. What is this? I'm so late with my responses. Yes, this is the defendant here. This is Karen Reed, and these are her attorneys. Okay, I have another timestamp,
please, because you may need your notes. But Ms. Little, did you find the Proctor testimony?
I did, Your Honor. It's
Hold on.
June 12th, 2025, the reporter's transcript at 1-148.
246.
And that's
Let's go to 246. Wait, is this? Oh, so I guess we're into the prosecution. Never mind. Let me hear what
from
the
the
question
copy of
was.
transcripts with sidebars, just
Okay.
for the court's reference, lines 8 through 12.
Great.
Thank you.
I have a question, Mr. Jackson, just about, so you argued obviously the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
10 p.m., Jerome. 10 p.m. 10 p.m. I was on time today. I showed up here. I started the live. I think it was 6 seconds to 8:30. So no complaints there.
In your pleadings, and again, you just saw, I want specifics where I can find something.
Yeah,
On page 28,
absolutely.
you
Fever.
talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29,
All right. I'm glad to hear that you're having a good day, Benji. That's always good.
2022. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as Dighton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding.
Oh,
just
never
took a
mind.
quick-
So they were just talking about the pieces that are actually in evidence. So let's get into the prosecution. I'm going to have to skip the prosecution as well because I just want to focus on the points that they made that I thought were good. I did not finish the prosecution though, so I'll have to find that timestamp.
Explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sally Port videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court
Man, this man always starts off like he's reading a script. Hold on. I like Braden though. In this case, the first time around, I don't know. The attorneys were okay. But this time around, I definitely like Brennan and I like Alessi.
Discovery came in.
It may be most helpful if I give the court history as I've learned it about the production of video in this case.
All right.
Okay.
And
We're
it will
gonna
explain
skip.
in context the production of video and will help create the foundation so the court can understand and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to
All
interrupt
right, I'm
you.
gonna skip these because I just wanted, to hear how he starts off because he's very poetic. All right. So let's go to 246. I believe that is the timestamp. We'll start 245.
Number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately.
Fever said he looks prepared. Yeah, he definitely. I just love listening to him. I love his use of language. Hey, what's going on, sir?
The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department
Oh, I see why. I see why I marked this. Okay.
in November. And as we've litigated extensively, so I'll simply.
Okay, and just so everybody's aware, this is the new special prosecutor in this case. He is not the prosecutor that presented this case during the initial trial. Okay, he was basically brought in to come and clean up the mess from this office.
Summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I've said.
Okay. So the reason why I highlighted this is because I've talked over and over again. I've reiterated the importance of the prosecution turning everything over, like don't play dirty. So to me, it appeared that he is my type of prosecutor. Okay. It's no secret. I used to be a prosecutor. That's how I started out. But turn over everything. So according to him, he invited the defense basically to, the Sally Port or wherever and said, look around, get whatever it is that you want, and then we'll take it from there.
And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station. I learned about the videos. And then as a consequence, I spoke to the chief, other officers, and the sergeant unexpectedly. The sergeant told me that he would click and drag copies of video when he would download them from the DVR.
All right.
Inevitably, we had the litigation about whether the defense was going to download in person or not.
All right. My next time stamp is for 248, but we'll just let it play.
As I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything. So I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review.
Okay, Jerome.
I was provided by
Jerome's excited.
the June 2023 CD with Trooper Buchanan's name on it. That is the exterior Sally Port video.
Okay, Fiva said it's a good vibe. All
and
right.
within 24 hours, I provided that to the defense. I then asked.
I'm sorry. Fiva said he's glad there are no dummies in here tonight. So I know that's funny.
And Trooper Tully and Trooper Buchanan to write reports since there was no chain of custody.
All right.
I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
Do you know which investigators filed?
All right. So this part, him basically having the law enforcement write reports because there was no chain of custody. Again, it just shows. It goes back. Let me look up the population. Hold on. I'm going to look up the population. I don't know. I may have done this. I don't know. I always like looking up demographics. So let me look up the population for Canton. What's going on? We don't want the zip code population. I don't see it. Okay. So 2020 census count of 24,000. That's pretty tiny. Yeah, that is for sure tiny. So I understand why. I'm not justifying their conduct, but I understand why the officers were behaving in the manner that they were behaving in. And that is not to say that there aren't officers that behave in this manner in larger cities.
What was found in?
Trooper Proctors.
Yeah, but what this pretty much highlights is the important, the importance of the quality of prosecutors that a jurisdiction has, okay? Because again, typically it really differs. It differs from county to county, okay? For example, the practice, the way that prosecutions are done in upstate New York is very different from how they're done in the city, okay? And what I mean by that is, in terms of prosecutor involvement, there are certain jurisdictions where the prosecutors are not as involved. Pretty much law enforcement investigates. They would then turn over the file to the DA's office, and then the DA's office pretty much gets a file and they show up for first arraignments. Whereas in the city, um, for the most part, the prosecutors are involved from the very beginning. From the very beginning of the arrest, they are involved and they pretty much direct the investigation of the case. Okay. But again, it's not always the case. It differs from jurisdiction to jurisdiction. To me, it sounds like in this county, or at least in this specific city, it sounds like the officers, law enforcement, they are the ones that were in charge of they're the ones that were in charge of directing the direction, not a good way of speaking. They're the ones that were directing the investigation. Okay, to me that's what it sounds like, because a, a lot of what Brennan had to undo, you would not have that problem if the prosecutors, and not just any prosecutor, but competent prosecutors, are pretty much guiding the investigation from the very beginning. Okay, so let's see, what do we have here? Okay, let's move on. Okay, so Jason emailed me. I'll take a look. Shout out to Jason. This is like the first email I'm probably getting in like 2 weeks, maybe longer than that. Oh, but I've not checked emails last night and today. Okay, what's going on here?
Okay.
What's this timestamp?
Your Honor, I have 3 separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
Okay.
Yeah.
All right, so we'll skip. I know this is not a good way of doing it, but I wanted to skip. How much time do we have? Let's see. Trying to figure out if I just let the prosecutor argue or do we skip? Because again, we only have until, we still have a little time though, but most of this I've watched. I did not find anything significant here, because that's why I want to move. I'm going to fast forward 10 minutes, but I did not see anything significant here, or did not hear anything significant. So let's go to 255. I'm looking for 250.
His meticulousness, if there was a need or a desire, when you
Baby,
look
this man uses the English language, okay?
at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it.
Oh, I remember why. I flagged this. Okay. All right.
And when
I'm
you-
just backing up a little bit so we can get the full context, and then I'll explain why I flagged this.
I agree with that.
Oh, wait, what?
Did not,
The Stoughton District Court motion?
it is.
Okay.
And I know the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in District Court, I think it's the Commonwealth's responsibility.
I agree with that.
And so, Attorney Yannetti, and I've mentioned this before, was very prolific in
FIVA, Karen Reed, the defendant in this case, I believe she was a professor or something along those lines, unless I'm confusing her for somebody else. But her boyfriend, the one she's accused of, offing, he is the one that was part of law enforcement. I don't know that she has any ties to law enforcement.
his pretrial discovery motions.
I know, but now that I think about it, I don't want to say these people had a drinking problem, but it sounds like they enjoy drinking. Okay. And I mean, there's nothing wrong with that, because I just had flashbacks of I think it was one of there. I believe he was an officer. He was a prosecution witness, and if I'm not mistaken, I believe he was John O'Keefe's friend, and apparently Karen Reed was trying to hook up with a man or something. She went over there. Um, I don't remember if they had drinks or not. Anyways, the whole thing is really messy. But I mean, human beings, that's like the nature. That's part of being human.
Very meticulous. And when you look at his meticulousness, if there was a need or a desire,
Yeah, I'm just gonna back up because I was doing a lot of talking, but he makes a really good point here.
ability.
I agree with that.
And so, Attorney Yannetti, and I've mentioned this before, was very prolific in his pretrial discovery motions, very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't.
Okay.
In fact, when you look at the perspective of Attorney Yannetti, you don't have to look much further than his characterizations of
Maybe Brennan is pretty much using the defense arguments against them.
how he sees the difference between the crime scene and the Canton Police Department. I've attached, for your honor and for the defense,
And again, this is a part of the argument. They were talking about, or at least the defense was arguing about Trooper Proctor's testimony. They were, they are alleging that Proctor lied. I mean, Proctor's a very shady character. But what I liked about, and again, it's going to depend on the rules. Uh, it's not to say that discovery rules change a lot, but it has happened where discovery rules uh change, and not often, but they do change. Okay. The distinction that I wanted to draw here, when he says that the defense attorney did not request the video. Okay. uh Same jurisdiction. Okay, I was in the same jurisdiction, and within, I don't know if it's a year or within a 2-year period, they changed the rule whereby initially it was upon the prosecution to pretty much just turn over all discovery, whether it was requested for or not. But then, I don't know, 18 months or something along those lines, they changed the rules where defense explicitly actually had to request for specific evidence. Okay, you just couldn't make a blanket. I mean, you could make a blanket request, but for motions and for hearing purposes, the prosecution would pretty much argue that the defense did not explicitly ask for XYZ. So I thought that was a good point that Brennan raised. And that's pretty much going to depend on the rules. I do not have time to take a look at the rules to see what are the current rules for discovery in Massachusetts. I mean, I don't do criminal law anymore. So I don't, I mean, I'm going to go back eventually, but I don't do it right now.
exhibit number 4, trial testimony of Trooper Nicholas
And
Garino.
let me see.
And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. reiterates, okay, well, Canton
Brooklyn, I never said that. Email me.
Police Department was not the scene of any crime, was it? So the defense is hard pressed now at this moment where they are trying to create prejudice that doesn't exist, to try to convert a motion that they filed with very specific intentions for physical evidence to now suggest that that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert.
Yeah, these folks, I don't know, they had a serious drinking problem.
In our
I mean, I suppose when uh, law enforcement, I suppose you drive drunk, because you don't expect your buddies to pull you over. Again, this is some small town stuff. That's definitely what people would do in a small town. So I suppose that's why, even for, I guess, officers do drink, the same with attorneys, maybe doctors, maybe everybody just has a drinking problem.
Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that, because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing.
Here's one thing about FIVA, okay? FIVA is going to talk about how people were hurt, okay?
Whatsoever. But if you look at Trooper Buchanan's
I understand what you're
testimony
saying, though.
on June 6, 2024, if you start at page 103, Attorney Jackson, to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position.
All right,
or
let
about
me
what he
look for the
saw,
next
that Trooper
timestamp.
Buchanan admittedly saw the inverted video.
All right, I'm quickly going to skip to, I think this is where I stopped, right before we actually get to the videos. Okay, so as far as the videos are concerned, okay, the videos, this is surveillance from the Sally Port, okay? So the defense is pretty much arguing that this was earlier on in the hearing. I didn't get to play it here. But the defense was pretty much arguing that the prosecution intentionally inverted the video, okay? Again, we're going to get into Trooper Proctor. What you need to know about this case is that he's a problematic officer. I, for one, do not even know how, I don't know how the prosecution can overcome how troublesome he is. The only thing I see them doing is pretty much what he did in the first trial, which is get up there, own up to everything, don't be defensive, and, keep it moving. But other than that, everything that this man has touched has pretty much tainted the prosecution's case. The defense, they are arguing that Trooper Proctor may have, what is this, tampered with a vehicle. Again, the theory is that Karen Reed backed into the boyfriend, and by doing so, he, got hit, and then he ended up dying in snow. There's evidence presented by the prosecution that, I don't quite remember if the tail light was just cracked or if it was actually broken and it shattered. Okay. What I remember from listening to the defense earlier today, though, they were arguing that the tail light was only shattered; it was not broken, and they are pretty much saying that in this Sally Port, the reason why the prosecution or law enforcement inverted the video is so that folks cannot see what Trooper Proctor was doing. They're pretty much claiming that Trooper Proctor was tampering with the taillight and breaking it off and something along those lines. Okay, so that's what we are getting into now.
A fractured taillight, if it's already gone before.
Okay, hold on.
About the Canton video, it's a red lean on. Mr. Barrows says more. And so if that taillight is not just cracked, that taillight is missing, then there is nothing exculpatory whatsoever.
That's true.
About the Canton video. It's a red herring, because there can be no plant of fractured taillight if it's already gone before it gets to Canton. There can't be. And so when looking at the evidence, it is unequivocally clear that piece of the taillight is missing well before that car ever gets to Canton.
Okay.
And so we can quibble and we can dispute and we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence, let's start first with the claim that the Sally Port videos were tampered.
All right.
Canton went back before January 29, 2020.
Okay, so from this, you can pretty much tell what the defense argument is. Their argument is that, the prosecution or law enforcement, they tampered with the video. And that if prosecution is saying, no, that's not it.
Too, and they took samples of the video to see if it was in the same condition, inverted for the
All right, let
back
me see
wall
what Jason's saying.
and fuzzy for the front wall. And we have those, and we turned those over to the defense. And I just want Your Honor to see a small clip of that
Honestly,
to
it's good.
show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now, this is 28 days before Ms. Reed's Lexus hits the Sally Port area. Now, you can see.
Oh, I see what they're saying. Okay, I did not watch this. So basically, this shows that it was already that's the state it was in.
From
Got it.
January 1st, 2022. Now, this is 28 days before Ms. Reed's Lexus hits the Sally Port area. Now, you can see, if you stop that, please. Thank you very much. On that wall, on that garage wall, there's a 4. It is backwards.
Oh, I
This
see.
Sally Port video was not
Here.
doctored by Trooper Proctor.
Got it.
It wasn't altered by Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that Sally Port. Similarly, front wall camera, could you please put on exhibit 3? Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the Sally Port. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police.
What the hell?
And this is the way the camera worked in Canton. Thank you
Wait,
very
let me
much.
go back.
The camera
Sorry.
is from January. Exhibit
Oh,
3.
shout out to LSU. It's March Madness, you guys. I'll be talking. Okay, I'll try not to talk too much about, women's college basketball, but I'm really excited.
From January 28, 2022, a day before Miss Reed's vehicle makes it to the Sally Port. And you can see the quality. It wasn't distorted on purpose.
Okay.
It wasn't manipulation by the state police. And this is the way the camera worked.
Honestly, Fever, I should not be saying this out loud, but I think no, I'm not gonna say it. I'm not gonna say it. I'm not gonna call. Never mind. Let's move on.
in Canton.
I've thought about it as it relates to this case, but I'm not gonna say it.
Thank you very much. And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen.
Okay.
Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle.
All right.
At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at exhibit 6, please.
This is my type of prosecutor.
This is from the ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Sally Port video is relevant to show
To show what?
that the Sally Port video is relevant to show
I don't know. To show what?
idea that the Sally Port video is relevant to show
Oh, that didn't come through.
break or planting of evidence. As Miss Reed nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in 2 spots so you can get a clear look
Okay.
of that rear tail
It's a
light.
big ass truck. An SUV. All right.
Forward, please. Thank you. And then ahead one more. You can see the white light shine. Stop. You can see it clearly missing. You can't plant something that's already gone.
All right.
And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white.
Yeah, I watch women's college basketball. But I love track and field, you guys. Like track and field, oh my goodness, I love track and field. Justin Gatlin, he has a podcast. Uh, I can literally, I was listening to it while I was working earlier this week. They had Usain Bolt on there. It was insane. But I do enjoy track and field.
The defense position is also contradicted by the ARCA witnesses.
Okay.
If we look at Dr. Wolf's testimony, day 31 of trial, it's noted as Exhibit 10 in our package, page 36. ADA Lally asks the good doctor, now doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from the review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight.
Yeah, I love track and field.
The defense position is also contradicted by dash cam
I
footage.
lose my mind. Like the last Olympics, I was home, so that was not as chaotic. But the ones around, I think it was 2021. It was during COVID because I remember I was working for Legal Aid at the time. I was in the parking lot because I think they were somewhere in Asia. So the what is this? The time zones were off. I was in the parking lot screaming. I love track and field. I love track and field.
Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day.
Like I'm already prepared for 2028. My family, everybody knows we're going we're going to the Olympics in Los Angeles. So I have my Alexa set up in 2026. I start with my hotel rooms and we take it from there. I'm really excited.
And when he did,
and then we have the what is this? The outdoor championships this year. It's usually around September, October. So I might disappear around then, you guys. I'm letting you know in advance.
He had a dash cam video further reinforcing that taillight is missing well before that vehicle makes it to the Sallyport area. If we could play Exhibit 7, which is the dash cam footage showing Mr. O'Keefe's car and his...
Jason, I thought that when Jennifer McCabe Googled how long to die in snow, I thought she was at her home. I don't remember her to have resided in the same residence as the Alberts.
Driveway at 8:22 a.m. If you could close up to the court, please. If you compare the right side to the left
Dang, edit your what? Edit your images.
side.
Maybe I need that. I need some AI. I need to work
Although
on my
covered and
thumbnails.
impacted by snow, if you could close more close up, please, you can see that taillight, just like the detective in Dighton said, just like the 508 ring video shows,
Okay.
is missing. Is missing. There's no plan. The defense's position is also contradicted by the alarm.com video that we received pursuant to Rule 17. There are two videos, 8 and 9. If we could play.
Here's the thing. I'm Apart from the fact that Brennan knows how to argue, I think he is easier to listen to because he does not raise his voice. You guys know I cannot stand attorneys that are yelling and screaming. That's not my style. So he's pleasant to listen to and much easier to follow.
Exhibit 8, please. This is the defendant's car arriving in Dayton in the driveway.
Yeah, but in all fairness, Fever, the woman, the Jennifer McCabe that Googled that, her testimony, she said that she Googled that at the direction of the defendant, okay, her friend. And she was not, I don't remember her being in the Albert home when she was looking that up. I believe she was home. Dang, that's a lot of snow.
The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. What are they stopping for? We can play video 9. And this is when the car is being put on
Dang, Big Brother everywhere.
the tow truck
Sheesh.
before it makes its canton.
And I mean, the weather is really bad. Why were they out? I don't know. I don't know. Alcohol doesn't stop anybody, I suppose.
And just like 508 in the driveway of Meadows, John O'Keefe's home, you will see that right taillight.
You must have some
Shine
serious
light
snow tires.
showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
We can.
Oh, I was listening to this when I was in the shower, so I realized, okay, so this is what Bev was talking about.
Can you zoom in on it?
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light missing video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Okay,
If you look at it on a small screen, see right there?
I do see it.
Yep, and then you'll see it again. So the alarm.com video contradicts the defendant. Anything exculpatory
Okay.
about these Sallyport videos. In fact, this whole idea of third party or plan doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense position
Okay.
that there's any relevance to the Sallyport video, that there's any type of is from herself.
What's going on?
Ms. Reed.
Oh, from the defendant? What on earth did she say? Oh, I think, isn't this the interview? Hold on. Oh my goodness. Let's see, because I listened to part of this while I was in the shower. Let's see. All right.
Herself. Ms. Reed spoke to the boss on June 20th, 2000.
Let me restart this, okay? I don't know why it's buffering. So 3:13:12. One moment.
Sallyport videos. In fact, this whole idea is indicted. Perhaps the best evidence that contradicts the defense position that there's any relevance to the Sallyport video, that there's any type of
I know I
is
turned that.
herself. Ms. Reed spoke to the boss on June 20th, 2023. And in that testimony, or in that interview, she said,
Spoke to who? That's a part that I did not hear. She spoke to who?
on June 20th, 2023.
A boss?
Ms. Reed spoke to the boss on June 20th, 2023.
Girl, hire an attorney. What are you doing?
And in that testimony,
Why are you
or
talking?
in that interview, she said, I was seized. There was a
No, hold on. I don't like this. Let's find Core TV because I'm curious. I need to know. Karen Reed. Hearing Core TV. I think it's this one from a day ago.
letter from Chief Rafferty.
Oh, actually, I might actually switch over to Core TV. I usually like Law and Crime, but the audio's clear. Let me see if I can find the audio's clear. It sounds good. No, I have to find. Okay, there we go. I think it's somewhere around here.
Perhaps the best evidence
Dang, that's so clear.
that contradicts the defense position that there's any relevance to the Sally Port video, that there's any type of plant by anybody, is from the defendant herself.
Okay.
Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out.
Why the hell? Why are you talking to anybody about this but your attorney?
At 5:45 before we drove
Why?
over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing.
Hold on, I need to zoom in on her face. Sorry. Why are you talking to what?
I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway.
What?
And so I say to the
Girl, what are you doing?
court, the production should have been sooner. It should have been cleaner. This should have been a log or an entry.
I don't know. Why is she being interviewed by her boss? Why is she talking? Or why
The
was she
failure to
talking?
provide was inadvertent. It was unfortunate. It shouldn't happen. But it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential.
No, Alessi is here. He's doing something. He's cooking. Okay.
because the evidence is overwhelming that light is missing before the car makes it to the foot of the Sally Port, so there can be no plan. That is my argument regarding the Rule 14
Okay.
issue.
And now the jurors.
I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence.
Okay.
And I think it's important for me to be able to address it. May I?
Yes.
That judge is short. Okay. I don't know. I've never figured it out. Is she impatient? I don't know. There's something there.
The claim of jury tampering is probably one of the most serious claims that one can make, because it's not simply an attack on a case. It questions the
wow.
fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider.
Jason, again, from an attorney perspective, from the perspective of somebody that's in court all the time, I guess that's why I said maybe I'm jaded, so I'll leave it alone. But it's not just that. Even if we go back to Dr. Russell, okay, let's go back to Dr. Russell, because that's the thing. I'm not to play devil's advocate, but I do like to be fair in my assessment of the parties. And obviously, I don't lean either way. If somebody makes a good argument, then I say it's a good argument. But consider this. If we go back to Dr. Russell, I think I just closed that tab. Why did I close that tab? In any event, when Dr. Russell is being asked, I believe she was being asked to explain her methodology or something along those lines, she pretty much pointed to the dome, okay, to her head, and she said it's all in her head. So it is not inconceivable. Do you want a witness to write everything out? Of course you do. But in reality, in practice, that's not how it always happens. All right, let's see. How much time do
Consider
15
evidence
minutes.
because they do not trust the system to begin with.
Okay.
And if a government actor
Oh,
or a
these people are
trooper or a police
reporting.
officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen because of the collateral consequence of tampering with the jury. It would take away the community's belief in our system.
Okay.
On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial.
I don't know. Why
to
does it keep
impede
looking at it like
the
that?
ability to have a fair trial? It is
looking at
an
Brennan like that?
extraordinary claim. And it's notable, the defense motion to dismiss. It's not just a motion to dismiss. It's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage.
Okay.
And why I'd rather sit down, as I said before, a lie unchecked becomes the truth.
Okay.
And so how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now, it's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be rebutted.
All right.
And it's not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning, not a coincidence. And so during this interview that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question, one of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury? Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well into trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors.
All right.
That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest.
Yeah, I mean, the law enforcement, again, in this case, questionable, very questionable conduct.
Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand. I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively. The next step is they have to identify a target. Who are they going to blame? Who's going to be the villain? In this case, the villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning.
Where's Brooklyn?
Lieutenant Fanning is one of
He's a
the
little quiet.
most conscientious, dedicated, admired state police officers in Massachusetts.
Oh, okay.
After having his
Brooklyn.
name attempted to be sullied all over social media, attacking his integrity and his name.
Here's what the defense is alleging. The defense is alleging that an individual that is tied to the investigation of this case was in charge of the jurors. The court and the court and the district, not district attorney, the court and the Commonwealth, the prosecutor, they're saying that is not the case. It's pretty much an argument. The prosecution is saying, or the defense is arguing one thing and the prosecution saying another.
I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable.
I don't know. She's losing her mind. Karen Reed's mom out here is like, oh, will you believe this guy is trying to lock my baby up?
I can dare say that
Disbelief.
Lieutenant Fanning is in a different position than many. His integrity is so reputable. None of that will break him or his reputation.
Okay.
But it happened. When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True.
Jason, what are you saying?
But then they leave off the punchline.
Which is?
They put this in a public document. They tried to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures very strong measures when they found something that they were not in agreement with. They concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the pleadings. Counsel was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Probably.
Yes,
Oh,
it was last year, last fall. I can provide the date right now.
Okay.
What the
Black
hell?
Being filed.
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor, sorry. It was July 17th, 2024.
Okay.
He is similarly situated to the many first responders and witnesses in this case. And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security.
Mm-hmm.
He had control of the jury, and he had access to the jury. Think about what those statements say to our community, who are going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways.
Oh, I do remember that. I do remember that.
In the trial courts over the past 30 years. In the heartbeat.
But I don't exactly know how somebody can make that assessment. I know how somebody can claim that a specific juror appears to, especially when a case has not concluded, when all the evidence has not been heard. I know how an individual can claim that a specific juror was much more likely to, acquit a defendant. Because to me, that pretty much says that it is an individual that was not prepared to listen to all the evidence and only form an opinion at the conclusion of, the case. And that is problematic. Jerome, I told you to put your finger on the phone, okay? Need to put your finger on the phone. Okay, all right. And Jerome, you're coming when we have like
of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges.
Okay.
They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion. The trial court personnel throughout the state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury. And these trial court employees, especially here in Dedham, some of the finest, would never abscond that duty. And yet it is now in the public domain, this suggestion.
What movie is this?
The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record. Fact. Lieutenant Fanning was not in charge of juror security.
Okay.
Fact, Lieutenant Fanning did not have control of the jury. Fact, Lieutenant Fanning did not access the jury. Fact, Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact, Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact, at all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror. Fact, no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning.
Yeah.
Fact, Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact, Trooper Fanning never investigated, approached.
Yeah, and that's the thing. Again, I mentioned this because I did not watch the rest of this. To me, it is problematic if a juror claims that they are leaning more towards one side when the case has not concluded. That is problematic. That is a biased juror. No matter how the defense tried to spin it, frankly, that's, I guess, somebody that's not really prepared to uphold the juror oath. So I don't know. I have questions.
Or inquired. He heard the information and provided it to the trial court as is responsible, dutiful,
He
and
was in
proper.
fact.
And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled, or met with any juror.
One ever is
Your
fine.
Honor.
We don't need all that.
These claims in the motion to dismiss
Okay.
have a theme. Different issues, same theme, same pattern, same
What's the
effort.
theme?
Your Honor should dismiss it outright, and we should move to trial. Thank you.
I don't know
If I may,
why.
Your Honor.
Why is Jackson all? I don't want to say
Thank you.
flustered, but what's going on? Why is he red? I wanted to hear, what time is it? 10:02. I wanted to hear. I thought Janetti was gonna get up here. No. Oh shoot, we don't get to hear from him. Oh no, is that him? Yeah, there he is. That's really who I want to hear from, but I gotta go. Okay. I need to go. I'll listen to this while I am at work. So I'll listen to that. We will be live on Monday. Okay. Tomorrow's Friday. I'm doing my laundry. Okay. So Jason said this is the best part. But I cannot stay, folks. I have to be up early. I need to fix my kitchen. I need to iron. And I'd like to be in bed. I need to talk to my man, and I need to be in bed within the next hour. Okay. So, okay, I was gonna watch this by myself. Apparently Jason's objecting, so let me see. We can either watch this on Monday or we'll take it from there. But I definitely need to go. Okay, so tomorrow I cannot be here because it's Friday. I'm doing laundry. Saturday. What am I doing on Saturday? I'm not sure, but I'm parenting. Okay, I'm parenting. I'm spending time with my kid. Sunday, I am going. Colin Griffiths. Hold on. So Saturday, no, I need to open a new tab. I don't want to close this one because if I close that, I mean, I could close it because I think I know where to start off. So Sunday, I'm editing Colin Griffiths. I want to create an actual video that I'll post. So we'll reconvene on Monday. Let me just to go here. Colin Griffith. This is for fever. Colin Griffith. I think it was day 6.
We have a verdict in the deadly.
Hold on. Not you. Okay, Fever, are you ready? Okay. Are you ready? Because they have the verdict, okay? This is when the verdict, no, not there. Why did I go so far? Oh, why did I go all the way back there? Never mind. So they reached a verdict. I just want you to see exactly everything that happened, okay? All right. Jason believes that Bev Canoni is biased. Okay, why am I going back? Yeah, so we're gonna have to watch that together on Monday. All right, thank you, Fever. Fever, I have it up here. I have it up here for you. I have it up here. You guys are so kind in here. That's very kind individuals.
Of 24 CF 8410, Mr. Griffith is present with Ms. Thornhill and Mr. Hendry. Mr. Levine is here for the state. I understand the jury has reached a verdict.
Yes, dude.
Let's have the jury, please.
All right, jury, come in, come in, come in. Yeah, he is. I don't know. I could not tell what was going on here, but he was pretty much patting the attorneys on the back and, saying, you guys have done all you could have done for me, and now it's in the hands of the jurors. But shout out to all public defenders. All right. These folks work. All right. I don't hear. Let's move on. Where are they? I don't know. Now that I'm looking at this, he appeared actually a little more giggly, I suppose. He was a little tickled even before the verdict was read. All right, come on. Come on, jurors. Public defenders out there cheering him up a little bit. All right, then we have Mr. Levine all by himself, solo, dolo, needs no backup. All right, come on, folks. Did I go that far?
All right, please.
All right, are you ready, Fever? Fever's funny. All right. Fever, are you watching?
Please be seated. If you are the foreperson, please raise your hand. For the record, juror number 1980896 has raised his or her hand. You may put your hand down.
Right.
Juror number 1980896, if the jury has reached a verdict, please raise your hand. That juror has his or her hand raised. You may put your hand down. Please pass the verdict form to the bailiff. There are no defects nor omissions in the verdict. Counsel for the state, counsel for the defendant, rise and hearken to the verdict. Mr. Griffith, rise and hearken to the verdict.
State of Florida versus Colin Griffin. With the jury, found as follows. As to the defendant in this case, the defendant, as to count one, the defendant is not guilty. As to count two, The defendant is not guilty. So say will, this 5th day of February, 2025.
Does the state wish to have the jury?
There we go, Fever. Colin Griffith was acquitted on both counts, the kidnapping and the murk, okay? So I don't know. I don't know if you have processed that, if you need time to process that. But in all fairness, uh, again, the biggest difference for me, just watching the case from top to bottom, the biggest difference is the stand your ground. I think Viva said, "Oh," Viva said, "Viva is shocked." Viva said, "Wow." so, so yeah, to me, I believe the determining factor for that case. I'm sorry, I cannot get over your shock. Uh, and I mean, when we finished this on Sunday, I think everybody was shocked. Brooklyn even said that was a BS verdict. Okay, but the biggest difference in this case is the stand your ground law in Florida, and also the defense. The defense did a brilliant job, pretty much making sure that they turned this case from the defendant to the victim. Okay, so this case was a good show. Apart from, despite the verdict, the prosecution and the defense in this case, they definitely put on a show. You could tell, at least I could tell, that these are attorneys that were in court arguing, you know, all the time. They're used to trial. This is their bread and butter. But this was a good case. This was a really good case. All right. Jerome says, I just saw this the other day, Fivo. Essa was wondering where you were. That's true. I definitely wanted to know Fiva's opinion on this. Maybe one day we can get Fiva up on the panel. Okay, but yeah, this was a good case. I mean, the verdict was a shocking, absolutely, it was a shocking verdict. But I understood why the jury reached the verdict that they reached, and that was my reason for actually watching the case from top to bottom. I just wanted to understand how the jury got to the not guilty. All right. Jerome says, I love this lineup. Fever, Brooklyn, Jason, Oldback, Benji. It's fun. You need to include my girl Callie in there, okay? Okay. Uh all right. Okay, so Fever believes in stand your ground, but it's different to where he was born and raised. Okay, all right, Fever. That's where we'll leave it. That's where we'll leave it. I'm not gonna read the rest of that. All right, folks. So we will reconvene on Monday. Okay. We will reconvene on Monday. And then Fever wanted to know what the next case is. I have some pretty exciting stuff planned. Okay. I have some exciting stuff planned, but I do want to focus on this Karen Reed case just a little bit. Trial begins April 1st. Trial begins April 1st. So I want us to do some background work. I want to cover all our bases, so we all know what we're getting into come April 1st. Apart from Karen Reed, I also really want to focus a lot. I want to prep us for the fall, and we're going to tackle the Brian Koberger case, okay? But hopefully we get shorter cases in between. There's another case out of Florida. That's going to be a really quick case though, because yeah, it's another case out of Florida. So you guys know I'm gonna come with that mess. Sorry, folks, I'm parenting on the side. This girl needs to be in bed. And usually when I come up here, she's asleep, but she has found her ways, okay? She likes to eat slowly because she has to eat, and she thinks that I'll come up here and I'm completely gonna forget that I have to parent and that she has to be in bed. Let's see. Yeah, so I mean, if you do have recommendations of trials that you want to watch, let's get into it because I can watch any trial. I know that I've not found a boring trial yet. I do enjoy trials. Okay. Okay, so Fever said, "Yeah, let's start a live stream and talk about everything." No, I do have some shorter videos lined up. I have my memory sorted, my man sorted that stuff off for me, so I should have no complaints. I just need to find time to edit. I'll miss you too, Jerome, but um I have to use the weekends wisely to edit the videos because during the week I'm extremely busy. Okay. And then I cannot deal with these two New Yorkers. So, okay. No, not Brian Kober. It is Brian Koberger. It's KOHB something. So, but looked it up and I think it's BRYAN. I might be mistaken. Maybe it is BRIN, but it's Brian Koberger. Just look up Idaho Brian. I think even Idaho Brian is going to come up. Search Idaho for search Idaho college students. Anything will yield results for you. Okay. So this Brian Kohlberger guy, he is accused of, offing college students. Okay. It's a it's an intricate case, but the case also has really good legal issues. Because today I was following, something came up. They reported, and I did not really get that into it because I was at work. But in that Brian Kohlberger case, the prosecution is seeking the death penalty. Talking about the death penalty, South Carolina, I believe they are going to carry out. Um, is it this month? I don't remember. It's either this month. I believe it's this month. In any event, South Carolina or is it North Carolina? One of the Carolinas. Let me look it up. Actually, let me look it up while we're here. Firing squad. Ooh. So I think it's South Carolina. South Carolina. I forgot the defendant's name. Okay, so let's see. Okay, so it is South Carolina. So South Carolina, they're pretty much going to carry out their first firing by squad execution in 15 years. Okay, the defendant, not that if he's convicted now, but Brad Sigmund is scheduled to be executed on Friday, and they're going to have a firing squad on him. I was interested because I wanted to take a closer look at his case, but I'll do that in my spare time. Anyways, the reason why I'm bringing it up is in line with Brian Kohlberger. Um, they are seeking the death penalty in that case, and apparently they're going to have a firing squad. As I don't know. In any event, Brian Kohlberger, that is definitely a big case. Sometime today, I came across a headline that DNA of three individuals was found under one of the victims. I believe it's the fingernail clippings, but I have to take a closer look at that. Okay, that case has really good legal issues. Okay, has good legal issues, and that's why I'm interested in it. Okay, all right. Let's see. I think. Yeah, I love New Yorkers. Okay, and apparently New Yorkers love me too. All right, so let's see. Let's see. I think we're done, folks. You guys know I can talk and talk and talk and talk. 18 minutes in. I should have been gone by now. I definitely need to go. All right, I will see you guys on Monday. On Monday, regular time, 8:30 p.m. Eastern time. We are going to carry on with the Karen Reed case. And Jason, I got your email. I just have to read the email. Okay, so that is what we tackle actually. On when we come up here on Monday, we will finish up the hearing. Okay, we didn't get time to finish day one, but I will watch day one on myself by myself. And if there, notable moments or points that the parties raised, then I'll come back and we'll do the same thing where we're just gonna go, timestamp to timestamp, and then I'll take a closer look at that decision that Judge Canoni issued regarding the dog bite. And I think, honestly, in order for the Karen retrial to make sense for everybody else. Apart from, because I don't even know, because that trial went on for an extended period of time. Okay. So I think it's going to make sense for us to actually watch Trooper Proctor's testimony and the cross in order for folks to understand how problematic it is. Okay. All right, folks. I need to go. I need to go. Love you guys. I'll be back on Monday, 8:30 p.m. Eastern time. All right. Shout out to Fever, Jerome, Brooklyn, Benji, Jason, Obag, Callie. I hope I did not forget anybody, but all right, I need to go. I really need to go. All right, bye. Bye. Good night.